any of that 15 minutes for rebuttal time?
Sure.
And how much?
How about 5 minutes?
Okay, I will keep your time, and you may proceed when you're ready.
Okay, I'm going to be on. I'm not particularly prepared. I've had some life issues that I'm dealing with, and I'm also had a lot of connectivity issues as far as being able to access information at this point. So I'm kind of, you know what? So like I said, I'll probably just try to do the best I can at this point, because I really haven't had quite the opportunity to prepare, I guess.
That's fine.
Yeah. So like I said, in this particular case, I had several assignments of error. The first two primarily centered around subpoena power, subpoena issues, what the requirements for the trial court, what are the requirements as far as ruling on a subpoena and any motion to quash a subpoena. Beyond that, I think there's some interesting issues there. Like I said, there was
Fields. What evidence did you have that the officer may have accessed your social media, or what was the basis for that concern that triggered the subpoena?
There are some things people had said previously in different states that basically indicated that, like I said, indicated something was that they knew who I was, even though I've never been there. I've never met them. It was obvious that they knew who I was. I'm trying, like I said, there are things people had said that indicated some elements of I don't know, personal knowledge of things that I may have, like personal knowledge of I don't know, things that would have only been able to monitor me on electronic devices or something like that. Previously, I just got back from an issue with a speeding ticket, and that was the concern when I was driving back from that, and that was a very interesting experience through the legal process with that, and that was sort of the basis for that stop. That was directly told to me by the officer that was there, and that was in Tennessee. And I really had no business in Tennessee. You know, I may have visited once or twice, at different points, but that's pretty much it. It was obvious the cop, based on things that he said, knew who I was, and obviously knew or seemed to indicate some manner that my certain electronic devices of mine were being monitored.
Mr. Finler, are you saying that the officer in Ohio, or are you talking about Tennessee?
No, I'm talking about in Tennessee, but Tennessee, okay. Remember, I got back from Tennessee. So when I got stopped in Cincinnati, I was coming back from Tennessee. So that was after that. And the Tennessee stop was that was the Tennessee stop. That was the trial that I had in Tennessee. And that was the interesting, like I said, an interesting step through the legal process as well. And what happened is I was coming back from that.
Mr. Finler, you put the officer, so the officer was on the stand testifying in your case because you went to a bench trial, and you questioned him about this. And he said, this particular officer in Ohio said that he never had seen you before. He never was on social media, and he had never seen you before. So what evidence do you have that that was not the truth?
Like I said, just based on things that I had seen as far as a campaign, that would be wrong. And I like I said, I can't go through every single example of people that I've met and talked to, or things that I've seen, or things that they have said that indicate some manner of my device has been monitored. It would be a lot of particular cases, but it spans at a minimum several states, different jurisdictions, things of that nature. I can't, it's one of those things. I can't say specifically that he did. In Tennessee, it was a different situation. He literally said it during the stop. The officer Detmer didn't. So, it's one of those things I can't.
Mr. Findler, sorry to interrupt again, but
that wasn't my basis. But that wasn't my basis of the appeal, though. My basis of the appeal wasn't.
Mr. Findler,
like
Judge Krause has a question for you.
Yeah, your argument on appeal is that you were not given an evidentiary hearing on the motion to quash, right?
Yeah.
Okay. So what would you have brought out at this evidentiary hearing to demonstrate that your subpoena wasn't more than just what they call a lot of cases a fishing expedition? I mean, what specifics? You're talking about other states, about this particular officer having this information. What information were you going to bring out in an evidentiary hearing?
Well, that was because it happened right after I was coming back from Tennessee. Okay, so like I said, there's an issue with the clerk of courts in Tennessee. I left because of some issues that happened while I was there. And then on my way driving back, literally right after I drove back after that, I was stopped. Now, granted, so that was the main point. Now, I didn't bring that up because from my standpoint, if there was something, I thought I try to keep my questions tailored to the particular situation around that event. So it was near or around. So I don't know how you could say it would be a fishing expedition because it can be a yes or no question. So it from the standpoint of it's near around the time, I'm not asking for something 8 years ago. I'm asking for something near around the time. And if that was the basis for, if that was the basis for the stop, then why wouldn't, what harm could come from it? So if he was looking at something near around and that was part of the basis for why he pulled me over, then that would be relevant within a judicial proceeding. Whether or not that, from the prosecution standpoint, they never actually brought that up. They were saying it wasn't relevant. And I think the prosecutor Donovan, he basically said it's not relevant, not specific. But I think it is relevant since it was near around the time, and if that's the basis, if that would potentially be the basis for a stop, that would be relevant. And I don't think anyone can say that subpoena wasn't specific. And those were his exact quotes. So that wasn't even the basis for what the prosecutor actually was going to quash the subpoena on. That's kind of my point there. That's kind of more, I mean, at this point, that's kind of more of a side thing. But I will say that when mine is more about judicial bias, and one can differ on their interpretation, but some manner of hearsay, or I don't know if you can consider it hearsay, but I believe it would be a Sixth Amendment violation. And that's my third and fourth assignments of error. I think those are what I wanted to particular focus on, because even when he was quashing the subpoena, he didn't even know what he was quashing in respect to me. He said I'll quash his motion and a subpoena. Okay. He didn't even know I wasn't making a motion. It was a subpoena that I had issued, and he didn't even know what he was quashing in respect to me, but he decided to quash it anyway. So that's one thing. On the third assignment of error, he made some really, he had an outburst the trial court had an outburst saying that nobody knows me. Nobody knows me on social media. Nobody knows my history. He does not know nobody. Nobody's talking about me. And, you know, even if that were, it almost couldn't be true. But even if that were, it's still, the trial court's basically stating what other people would say about me if they were to testify. I think that brings up some
Mr. Findler, this is Judge Krause again. The officer did testify, and you were permitted to ask him those questions several times.
Yeah,
and he said that he didn't know who you were.
I think some of the questions he was more direct on, and then other ones he was more evasive. And so what I was trying to do was trying to ask questions in different ways that kind of centered around, it did center around something similar, but I try to ask it in different ways to try to find, to, like everyone, to ascertain the truth of what you're trying to get at.
Did the officer answer your questions?
For the most, like I said, he answered the questions, but hold on, I'm trying to look at some of the notes. My issue is that my issue is less with the officer, beyond any, like I said, beyond any other issues. It's more with the court.
Well,
and that was sort of the basis of my appeal.
Mr. Findler, if you want your rebuttal time, you're at the end of your argument time. If you want to save some time for rebuttal.
Okay. Well, can I go on for 2 more minutes, and I'll save like 3 minutes at the end for
sure, because
for rebuttal.
The way the process works is then the state gets to go, and then you can come back with whatever time you've reserved. So if you want to go for 2 more minutes, and you'll have 3 minutes left for rebuttal.
And I'll have 3 at the end. Okay. And I just wanted to mention, okay, so that's one point. And then overall, based on both kind of the cavalier manner, and he was quashing the subpoena, and the manner in which he kind of attacked me, stating that sort of it was a loud outburst. Nobody knows me. Nobody knows your history. Nobody, and he went on and on. And then some other things. My fourth assignment was judicial bias. And basically, in some of the court cases that I saw, like State versus DeMarco, and then I think it brings up, and I will say I didn't object to some of those outbursts at the end. I was it was a very fast trial. I didn't I should have. And that's one concern. But there were several things that he did, and he did it in a really fast sort of time frame. So, like, some of the things that I actually brought up that I thought were somewhat interesting is structural error versus plain error review. Like I said, I think that would apply from a judicial bias standpoint. Like I said, I tried to, granted, some of it was a little repetitive, but I was asking it in different ways, and I was actually asking different questions, because while he did answer the questions, he was somewhat invasive on certain of them, especially starting with the second question that I asked, I believe, regarding any kind of awareness of who I am. And basically, from that standpoint, I was trying to get at whether he had knowledge of, or whether anyone was communicating with him about anything that happened in Tennessee, which happened right before he pulled me over as I was driving back from Tennessee. I was literally driving back from Tennessee after that.
Mr. Findler, you're at your time now, so I'm going to turn it. I'm going to turn it over to the state for their argument.
Great.
Ms. Tucker.
Yes. Good morning, Your Honors, and may it please the court. Ashton Tucker on behalf of the City of Cincinnati. I'm going to limit my argument to what I think are the 2 issues that Mr. Findler is mostly addressing here. One being the quashing of the subpoena, and the second being the judicial disqualification. To start with the start with the quashing of the subpoena, the decision to admit or exclude any evidence rests on the sound discretion of the trial court, and honestly should not be disturbed on appeal unless there is some showing of an abuse of discretion, meaning that the trial court acted unreasonably, unconscionably, or arbitrarily. Here, in this case, Mr. Findler was offered the opportunity to be heard as to his subpoena, to present his argument as to his subpoena.
Should there have been an evidentiary hearing?
So our position is that the oral arguments held that day in court should be sufficient. However, if the court sees otherwise, that perhaps that there should have been a hearing, that we would ask that the court follow the second district in Miamisburg v. Renderly and State v. Bennett. These were not cited in our brief, but I will be happy to provide a copy of them to the court if asked. Essentially,
which case are you talking about?
This is Miamisburg v. Renderly, that's Rinderle, and State v. Bennett. These are out of the second district. Ultimately, those cases stand for the proposition that if a hearing is not conducted before quashing the subpoena, that it would constitute harmless error if the subpoena was plainly improper. So where the record, as here, demonstrates that the subpoena plainly has no merit and would have had no impact whatsoever on the trial, that ultimately the court shouldn't go as far.
I guess my concern about that is, like, how do we know that it would be plainly ineffective without the evidentiary hearing to flesh that out? I mean, then we're just making conclusions on the face of the subpoena.
Sure. I think that because at the appellate level, you can look at the trial as a whole. You do get the benefit of hindsight. So if we're looking at this particular trial being the speeding ticket, the subpoena trying to get Officer Detmer's phone as it relates to the trial as a whole, I think we can see that this would not have been particularly relevant to the speeding ticket as of the date in question.
So your argument is the fact that it proceeded on to a bench trial, and we can look at the trial versus, for example, an interlocutory appeal situation, which I believe is what we had in our prior precedent out of this court, right?
Yes, exactly. Yeah. I think that is what distinguishes these two specific cases. And I do think that now that we can look at it from the perspective of already having a trial, knowing that this subpoena in and of itself would likely have been ineffective, or honestly just have no real relevancy into this case, that the choice not to have a full hearing is just harmless error, and we would ask that this court not overturn the trial itself or remand the matter to the trial court for a superfluous hearing based on that. To go on to his what seems to be his second major issue is the claim of judicial disqualification, that Judge Triggs was biased in some way. Pursuant to Ohio Revised Code 2701.031, the defendant must file an affidavit of disqualification with the clerk of the Supreme Court of Ohio. Further, the Ohio Constitution, Article 4, Section 5, does state that the Chief Justice of the Supreme Court or any judge of that court designated by him shall pass upon the disqualification of any judge of the Court of Appeals or courts of common pleas or division thereof. Further, the Ohio Supreme Court has found in Beer v. Griffith that they have interpreted that section to hold that the appellate court lacks the jurisdiction to hear matters regarding judicial disqualification. And this court has followed that in State v. Carter. The record does not reflect that Mr. Findler has ever filed an affidavit of disqualification, but even if he had, the jurisdiction of judicial disqualification rests squarely with the Supreme Court of Ohio,
Ms. Tucker,
and not this court.
Isn't his argument, though, that the judge was displaying bias over the course of the trial and therefore he was deprived of a fair trial because of that? And isn't that something that we as an appellate court can review when it comes to judicial bias?
I do think so, but I think that his argument as to that is essentially having him disqualified. While I agree that this court can look at judicial bias, I think that ultimately where Mr. Findler is going is pursuant to that section of the Ohio Revised Code. And again, I don't think that rests with this court. And if there are no further questions, I would just ask that this court affirm the trial court's decision, and I would submit as to the remainder of my brief.
Okay, thank you, Ms. Tucker.
Thank you.
Mr. Findler, you have 3 minutes for rebuttal.
All right, so let me just hit off on just the first part. And some of that might be true based on the answers from the police officer. I can see an argument where they can say, well, maybe the subpoena wouldn't have produced the information, the information that I was seeking, because some of my questions and some of the that's the whole point. There's crossover there. There's actual physical evidence or electronic evidence, well, primarily electronic, or questioning someone, testifying. My issue there is that there wasn't an evidentiary hearing, and basically, and that goes to my judicial bias point. The judge basically said he was quashing whatever I was bringing up, but whether he said motion, he actually said motion first, I believe, and then he said subpoena. He was like, I'm quashing your motion or your subpoena. It was basically just whatever you're bringing to the table, I'm quashing it. That's one of many points of what I'm trying to point with judicial bias, but from the subpoena standpoint, what I would say is that sometimes people can say things, but there's third ways to be able to gain information, even if it's not directly. Like I said, it probably wouldn't have produced what I might have expected it to produce based on testifying, but there was an evidentiary hearing, and you can't say there's differences in how people testify and what they would produce based on what's being requested through a subpoena. So, like I said, the prongs, the Nixon POTS test weren't met. But let me go back to the judicial bias, because I think there's some interesting points. One of the justices, I don't know who their name is, but she hit it right on the head. My whole point is that you can't put in a affidavit. You can't put an affidavit of disqualification unless you know that they're biased from the beginning. I just came to court. That's it. I didn't know who he was. I didn't know who the trial court was. Never met him. I didn't even know his name. That was my first encounter with him. You can't be expected to put in an affidavit of disqualification for judicial bias if you've never had any encounter with them and you've had no dealings with them. That's the whole point of that part of Ohio is for things that would have been preordained prior to stepping inside the courtroom. And that wasn't the case here. And like I said, there's multiple points of judicial bias. Case law is still strong. It's still strong as far as, like I said, there's loud outbursts. And it's definitely arbitrary what he says.
And Mr. Findler, you're at your time now. We appreciate your arguments. Thank you, both of you, for your arguments this morning. The case will be submitted, and we will issue a timely written decision. So thank you both.
Thank you.
Have a good day.
Thank you. You too.
And Mr. Waters, you may let the next participants in.
It looks like they're all in, Judge.
Okay. All right. Thank you. Good morning, gentlemen. Welcome to the First District Court of Appeals. Could I just have you each identify yourselves and tell me which parties you represent and who's going to be arguing this morning?
Sure, I guess I'll go first, Your Honor. This is Brian O'Connell, Strauss Troy, representing the plaintiffs, Harry Sandu and H&R Cincy Properties.
Mike Cusson, Your Honor. I represent defendant appellants.
Zach Prendergast, Your Honor. I represented the court-appointed receivers, since been discharged.
Okay, did the receiver, are you intending to argue today?
No, Your Honor. I was noticed on this, and I'm sort of more just an audience.
Fair enough. Fair enough. We'd ask you just to keep your mic on mute, just so there's no inadvertent interruptions. Mr. Cusson, would you like to reserve any time for rebuttal this morning?
I'll reserve 5 minutes, Your Honor.
Okay. You may proceed when you're ready.
Thank you, Your Honor. While I understand there are a lot of pleadings in this case and in the lower court case, I think the issue today before the court is very simple and straightforward. And that is, did the trial court have the power to order Norma Fontaine, Marcus Fontaine, Sinvesco, LLC, and the Dinah Towers Condominium Association to pay the costs of the receiver after they had been dismissed from the litigation?
Mr. Custom, before you get started, I just want to clarify that the one corporation that was not dismissed after the settlement agreement, Sinvexco, is that corporation, they didn't appeal, right?
Correct, they did not.
Okay.
Correct. So, yeah, so, and what this is the dispute between the two major condo owners in the Dinah Towers. The plaintiffs had control and own about 8. My clients own approximately 18. In 2017, the plaintiffs filed a complaint asserting that my clients had improperly amended the declarations of the condominium association and were mismanaging the property. Therefore, they filed suit. And during the litigation, they asked Judge Martin to appoint a receiver, which he in fact did. After the receiver had been appointed, the parties settled the case, entered into or signed off on a settlement agreement and release, as well as an agreed entry of dismissal, dismissing from the litigation Marcus Fontaine, Norma Fontaine, Sinvesco with an S, LLC, and the Dinah Towers Association.
I guess I don't understand, and maybe there's no real answer to this, but why was there a settlement and release before the receiver's work was done?
Your Honor, I was involved in the litigation at that point. I assume at that point it was done because there were some actions that needed to take place. In addition to the payments made to the plaintiffs in settling the case, they had to appoint Mr. Sandu to the board. They had to hold some elections and that type of stuff. Why they didn't wait and do all that and then put an entry of dismissal on at the end, I can't say. I wasn't party to the case. I wasn't involved in the case at that time. I agree with you. That probably would have been the more appropriate procedurally way to go, is resolve all the issues, then put the dismissal entry on. But I don't think there's any dispute in this case that the entry of dismissal was in fact placed of record, and those parties were dismissed.
Can I ask you a question on your appeal, though, just so I understand? It sounds like you are arguing, so they were dismissed, the parties were dismissed in September. The receiver was to continue on per agreement until February the 11th, right?
Correct. Correct.
And you don't have any problem with the money for the receiver up to February 11th, right? You're not appealing any of that money.
No, that money was paid.
Okay. How much are we talking about then after? I didn't understand from your brief how much money additional was racked up after February 11th.
Well, because nothing in this case, I think, is simple or clear with regard to some of the facts. Is what happened in this case is the payments were made to the receiver. I apologize, I have it here. He was paid, or the receiver was paid, the $2,000 for their initial, and these were the fees that the receiver had provided in his affidavit or support of becoming the receiver, is what his fees were. So $2,000 was paid. Then 6 months worth of $1,500 payments were made. Those were his monthly fees that he was going to incur. And then his wind down fee of which I believe is another $2,000. So all that money was paid, and the receiver in his accountings and his application for receiver fees acknowledges that those payments were made. What happened was
that's per the settlement agreement. So the settlement agreement lays out all
Yes.
of the receiver fees.
correct.
And there was no anticipation, because I mean, there is a part of the settlement agreement that says the fees as detailed in item 1 are exclusive of any other miscellaneous fees incurred by the receiver. Was there anticipation that there would be additional fees that would need to be paid up until February 11th by the defendants?
Again, I wasn't involved in it at that point in time. I didn't come involved in the case. I assume those would be the additional fees that would be incurred by the receiver, such as if they had to pay for repair to the elevator, or if they had to, those fees that the receiver contracts during that period of time for work being done at the Diana Towers.
Mr. Cusson, let me ask a question. I'm looking at the entry or agreed entry of dismissal from September 2018. And in that entry of dismissal, it says court costs to be paid by defendants. All right.
Correct.
All right. The next paragraph goes on to say that it's contemplated the receivership will remain in effect, at which time will conclude sometime around February 11th, 2019. Now, the thing is, as I said, it says court costs to be paid by defendants. And this entry necessarily contemplates that the receiver will continue, I guess, as an arm of the court in his ancillary proceeding. Now, my question is, if one of the dismissed defendants causes the court costs to rise, i.e. the receivership's fees for attorneys and other matters that it needs to attend to that weren't contemplated, shouldn't those fees be assessed against the defendants, because the entry clearly says court costs to be paid by defendants? It's a very lengthy question, but that's, do you have an answer to that?
I do, Your Honor. In this case, even if the court were to say, wait a minute, any fees and costs incurred by the receiver up and through February 11, 2019 should be paid by the defendants. That money was there. That money had been paid. There was money in the accounts. The problem is that after or before February 11th, in January, the plaintiffs went to the court and said, we need to extend this receivership. And the receivership got extended another 7 months. And when you...
Why was that? Why was it extended?
I don't know. What the plaintiffs said in their motion is that despite every obstacle by Mr. Fontaine is put in his path, the receiver has fulfilled his obligations under the court's order appointing the receiver. As detailed in the response filed by the receiver, he has complied with all obligations under the order and Ohio law. So the plaintiffs acknowledged that the receiver, because that's what the receiver was to do, he was to manage the property during the litigation. He had complied with that.
Who were the parties at that time when the plaintiffs filed that motion? I mean, were all of your clients dismissed at that point?
Yes.
So who's filing the motion? I guess the plaintiffs are filing the motion. Are there any other parties in the lawsuit at that point?
Sinvexco with an X was party to the lawsuit. My clients attempted to object to the order, and the plaintiffs, the receiver, and the court all said, you're dismissed. In fact, my client filed the writ of prohibition with the court. I apologize, in case C-19-0173, and said, wait a minute, I've been dismissed. Judge Nestor said, you've been dismissed. You don't have any standing to object to this motion or to argue with this motion. When the court continued the receivership, my client filed a mandamus and writ of prohibition in that case. And this court ruled that the relator has been dismissed as a party defendant. He has no standing to contest the trial court's exercise of jurisdiction. So what we have is the plaintiffs telling my clients, you can't object. We have Judge Nestor telling my clients, you can't object to this request to continue the receivership. And we have this court telling my client, you don't have any standing to object. Yet what happened was Judge Nestor continued the receivership and then ordered my clients, after they had been dismissed and after he said you have no standing to object, to pay for and be responsible for all those court costs.
And going back to my original question, I don't know if you can answer how much additional, because you're saying that everything that was in the settlement agreement, that was going to compensate the receiver, what you're arguing, up till February 11th. And then after February 11th, it was extended and there was additional money racked up that now your clients have been ordered to pay. How much are we talking about?
Your Honor, it's honestly, I haven't done the math on it, but it is the majority of the funds, because what happened was the receiver did not apply those funds to his fees and costs that had been paid by my client. He applied them elsewhere. And so he is still out and seeking those fees and costs.
So he hadn't been paid for his services. He was using the money to keep the building running, right? Up till February 11th.
He had been paid for a service. He applied it to bills for the building. Now, what can I say? Which bills he paid for? I don't know exactly which bills he paid for, but he had been paid, and instead of holding that money to pay himself as he was supposed to, as the parties agreed and as the order was, he applied that towards other bills of the property.
But your argument is that the money that was laid out in the settlement agreement for the receiver was the only money that the defendants were going to owe.
Correct.
Receiver. Okay.
Correct. And again, I don't mean to cut you off. If I did, I apologize.
No.
But if you look at the receiver's bill and his application, which was filed by the court, and I believe it was in September, it's document 184. If you look at that, there were enough funds between what had been paid by my client, what was in because there were funds in the account when the receiver took over. There was enough funds to pay the bills that he had supplemented or put in there and the bills for the association.
Mr. Cusson, you're at your 10 minutes if you still want to reserve 5.
Thank you. I'll reserve.
Okay. Mr. O'Connell, maybe you could start with kind of where he was going, which is it's pretty straightforward argument that if you've been dismissed, you shouldn't be on the hook for what happens afterwards. So tell us why he's wrong on that.
Certainly, Your Honor. And I think that there's a very simple answer to that, is that, in fact, Mr. Fontaine did remain a party and was subject to the court's jurisdiction just for 3 limited purposes. First, for purposes of enforcing the settlement agreement, which is something defendants have conceded the court had jurisdiction to do. Second, for taxing of costs, by virtue of the agreed entry that we've talked about many times already, entered on September 26 of 2018, that's expressly provided that the defendants would be responsible for costs. And third, for collateral issues. The court has inherent power to remain, even after a dismissal entry is put on, regardless of how it's put on. The court retains jurisdiction over collateral issues, which can include such things as the taxing of costs or imposition of fees.
Well, but taxing of cost, I mean, in my mind, that connotes costs that were incurred during the litigation, not afterwards.
Well, but the rule is not that limited, and especially given that the Ohio Revised Code section, let's see if I can find it here, 2735. Here we go. 2735.04C expressly provides that receivers' costs can be, or receivers' expenses can be taxed as costs.
But I guess, but that still goes to my question. That makes sense to me for costs and expenses incurred up to the time of dismissal. But what authority is there to say you, a dismissed party, can be on the hook for the receivership fees that accrue after dismissal?
I think that goes back to the inherent authority that the court has to resolve collateral issues after a dismissal entry has been put on record. if I may, hopefully that's answered your questions. Where I wanted to start today, if I might, is given all the rancor that has been contained in the pleadings, including those that I see Mr. Fontaine has filed just recently, as well as the dozens and perhaps numbered in the hundreds in the trial court below. I thought best maybe to start out on what is really not at issue in this case and what is not in dispute. First, the order appointing the receiver issued by Judge Martin in August of 2018 is not at issue. The defendants are not challenging Judge Martin's findings that because Mr. Fontaine's mismanagement and theft from the HOA was being run into the ground and a receiver was needed. That's the first issue that's not before the court. Second issue that's not before the court is Judge Nestor's decision in February of 2019 to continue the receivership because of the interference and the failure to cooperate of Mr. Fontaine. The only issue before the court is Judge Nestor's decision to tax the receiver's additional costs on the defendants. And on that, I think that there are three, and I'll go out on a limb and say as many as four issues that are not in dispute on that point. The first is that, as the defendants have conceded, and as I mentioned a moment ago, the court maintained jurisdiction after the dismissal entry was put on. They take the position that it was because of the settlement agreement. The court maintained jurisdiction over that. I maintain it's both because of that and also the inherent authority the court had that we just.
Yeah, but on collateral issues for inherent authority, I mean, that's usually stuff like you have ordered a party to do X and you need to enforce that order. It's like a contempt issue. I think that the conceptualization that you're giving to inherent authority seems to expand it beyond kind of what I think it's commonly understood as.
Well, Your Honor, I think that can be answered in the sense that, well, first of all, the court does have authority. After its order is put on, the court always has authority to enforce it. Under the agreed entry put on in September of 2018, I'm sorry, not the agreed, the receivership order put on in August of 2018, Mr. Fontaine was ordered to cooperate with the receiver. I think any objective observer would have to conclude he did not. The court had power to enforce that. Moreover,
but by contempt, I mean, I know you all asked for the court to find him in contempt, and that the court didn't do that though.
Either through contempt, its contempt power, or by virtue of the fact that that agreed entry or that the receivership order was part of the settlement agreement. So I think the court had two avenues under which it could have done that. Three really, but for purposes of your question, Your Honor, it could have done it either through contempt or enforcement of the settlement agreement. And as we talked about before, there's no dispute that the court had jurisdiction to enforce the settlement agreement.
But the settlement agreement only contemplated that the receiver would be in place until February 11th. And when the defendants attempted to object to the extension of the receiver, the court wouldn't even hear them because they were dismissed, right?
Your Honor, I'm glad you asked that because that's not correct.
Okay.
In fact, Mr. Fontaine, pro se, was not permitted to speak and be heard, although he had filed multiple pro se pleadings, which the court did read and entertain. I think that's a reference in Judge Nestor's transcript to that. But bear in mind that at that moment, when the court said, Mr. Fontaine, I don't want to hear from you, Mr. Fontaine was still being represented by Kyle Rapier, who was there on behalf of Sinvesco and was still Mr. Fontaine's attorney because Mr. Fontaine had tried to do a substitution of counsel in order to get rid of Mr. Rapier. But that was ineffective because, number one, Mr. Fontaine's not an attorney, so you can't do a substitution of counsel. And number two, to withdraw, Mr. Rapier had to, which is what he ultimately did, file a motion to withdraw.
So Mr. Fontaine was heard through his lawyer then, is what you're saying?
Correct.
Okay.
Through Mr. Rapier, that is correct. And I'm glad you mentioned that because I think that's a very important point. This is not a situation where Mr. Fontaine did not have an opportunity to be heard on these issues. He had an opportunity to be heard in January and February when the receivership was continued. Then at the end of this process, when there were filings by both the receiver and the plaintiff.
Well, why? I mean, I guess maybe going back to my first question to Mr. Custom, like you've got a very difficult party that you're dealing with, and you've got a settlement agreement. Why do you not iron out all things related to receivership expenses in that settlement agreement and have it all wrapped up by the time of dismissal, rather than, you know, inviting this situation that we have today?
That's a very good question. I'm glad you brought me back to that, because I wanted to address that, because I was in fact involved at that point in the proceedings. The fact of the matter is the HOA had been run into the ground. Mr. Fontaine had taken for himself $2,000 a month out of the HOA. There were no funds there. The insurance company for the HOA, or the board actually, was willing to settle by paying cash. I can't remember the exact dollar amount now, to settle this, which was desperately needed in order to fund the HOA and actually fund the receiver to allow him to get the HOA back on solid footing. So it was done because primarily because there was such a desperate need for the money. And it was also done in such a way to allow a party, Sinvetco, which was owned by Mr. Fontaine, to remain a party to the case for the duration.
And they're not appealing. So
Apparently.
they are saddled with the receiver bill.
Well,
no matter
actually, well, the defendants collectively are. That is true.
Well, I know, but no matter what happens in this appeal, whichever way we go, they have to pay, right?
Correct.
Okay.
Let me follow up on that, Mr. O'Connell. I'm looking at the settlement agreement that I know is not incorporated into the entry of dismissal, but it looks like in paragraph 9, it says Dinah Towers is responsible for the court cost of case number A17-05644, which is more restrictive than the entry of dismissal that says court cost to be paid by defendants. And again, I'm getting back to the point that at least in the settlement agreement, it seems to contemplate that the receiver will continue. And looks like paragraph 1, subsection E, it says the fees as detailed in item 1 are exclusive of any other miscellaneous fees incurred by the receiver. So let me ask, is the entry of dismissal that says all defendants shall pay versus just Dinah Towers, is that inconsistent with one another? Are those two documents inconsistent?
No, Your Honor, it's not. I would submit that the agreed entry, which was done subsequently, superseded that language and broadened the scope of who would be responsible for the court costs. I also want to mention that paragraph that you mentioned a moment ago about the fees being paid at that time being exclusive. That language was put in there very intentionally, because I did not want it to be limited to the defendant's contribution to be limited to what was being put in at that time. That language was put in very deliberately to ensure that if there were additional costs, the defendant would be responsible for that. And let me mention one other point that I think is important, and this is a point that is in dispute. In some of the filings, defendants have suggested that the plaintiffs never asserted that the defendants, Mr. Fontaine in particular, had breached the settlement agreement, and that is simply not correct. In fact, if the court would look to my filing, plaintiff's filing, on January 31st of 2019, what we said is, as detailed in plaintiff's prior motion and as discussed at the hearing on January 17th, it is the defendants, and in particular Marcus Fontaine, who has breached the settlement agreement and frustrated the fundamental objective of that agreement by interfering with.
Well, but if it's a claim for breach of the settlement agreement and the parties have been dismissed, you have to bring a separate action to enforce the settlement agreement.
Not here, where the court maintained jurisdiction over the receivership.
Well, but usually when I settled a case when I was in practice, if we wanted the court to maintain jurisdiction, we put that in the order and said the court will maintain jurisdiction to enforce the terms of the settlement agreement. And I don't see that in this case.
Your Honor, that express language is not in there. However, defendants have conceded that the court did in fact maintain jurisdiction for purposes of the settlement agreement. In fact, they state that numerous times in their brief, And bear in mind also that it was the defendants who in fact filed a motion with the court to enforce the settlement agreement. Mr. Fontaine filed that. Therefore, to the extent that that was somehow improper, that's invited error on the part of the defendants.
So if they didn't concede, would you agree that the dismissal order does not maintain jurisdiction over the settlement agreement?
No, I wouldn't in this case because of the unique nature of the settlement agreement and the continuing nature of the receivership that was put in place, that all the parties understood was going to go on.
And then if we go with that argument, the parties all agreed that the court would have jurisdiction to enforce the settlement agreement with regard to the receiver and the fees up until any fees that were incurred up until February 11th. How does these are parties that are dismissed and they are disputing the extension of the receivership. How is there any agreement to be enforced there? Because they only agreed up to February 11th.
Well, by virtue of the fact that they breached the settlement agreement, Your Honor, certainly the settlement agreement contemplated everybody back in August, September of 2018 thought, okay, we finally resolved this. Receivership's going to be put in place. Ship's going to be righted. That's not what happened. I mean, I lived this along with Judge Martin and then Judge Nestor, and it was just a barrage of allegations of intimidation of the receiver. And if the court would look, I'll recommend just one thing for the court to read, which is a 3-page filing actually by Mr. Pendergrass, filed on April 30th, I believe. Let me find that here. April 30th of 2019. It's very short, it's 3 pages long, but it very succinctly explains the kind of harassment, intimidation, interference that the receiver experienced here. I mean, I don't know whether the court is aware of this, but because Mr. Fontaine didn't like the way this action was proceeding, he subsequently filed a lawsuit in 3 lawsuits against my client's wife, the receiver's wife, the receiver's attorney, Mr. Pendergrass, and myself. And another case in Hamilton County, one in Warren County, one in United States District Court, the Southern District of Ohio. And the court has seen, I think, in its own filings here, the kind of barrage of inflammatory, scandalous allegations that are made. My point with all that being is that everyone had the expectation back in August, September of 2018, the matter had been resolved. Mr. Fontaine would not let that happen. It did not happen. He breached the settlement agreement by failing to cooperate as required by the court's order. Judge Martin and Judge Nestor lived this, they knew it. They understood and agreed with the plaintiffs that Mr. Fontaine had interfered with these efforts and should bear the cost of it.
This seems more of a sanction against Mr. Fontaine, and yet all of the dismissed defendants are being required to pay for it.
Well, bear in mind that those dismissed defendants were basically him. They were his entities. So it all lays back right at his feet, Your Honor. And again, in my mind, if the court reads and understands what was happening here, I think the answer is very clear. The court had authority through multiple mechanisms. The court chose to do it under enforcement of the settlement agreement, which again, defendants have conceded the court had jurisdiction to do. And bear in mind that what the defendants are asking to have done here is to have the plaintiffs bear this cost.
And do you know how much money we're talking?
Oh, yes, I do. It's
after February 11th?
It's $79,000. Now, not all of that, yes, $79,000. And one of the reasons—
Is the $79,000 the total amount for the receiver, or is that after February 11th?
It's a little bit of both. I've not done the math to tell you which, but what I can tell you though, is beginning in January of 2019, after it was becoming clear the receivership was going to be extended by court order, Mr. Fontaine stopped paying the HOA fees for all 18 of his units. That's $5,000 a month. And he didn't pay it for 9 months. That's $45,000. So of that deficit of $79,000, more than half of it is directly attributed to the fact that Mr. Fontaine, despite the court order that said he was required to cooperate, he didn't. I mean, he, in the most fundamental way possible. I mean, putting aside all the.
And Mr. O'Connell, I hate to interrupt, but you are at your time.
Okay, well, thank you very much, Your Honor. I kind of thought that would happen. But in closing, just let me say, I think that it would be inherently unfair to punish the plaintiff for the misconduct of the defendant. We would ask that, first of all, for the court to find that under the standard here, there has been no abuse of discretion by Judge Nestor. We ask the court's September 12, 2019 order terminating the receivership and assessing the court be affirmed.
Thank you, Mr. O'Connell. Mr. Cusson, you have 5 minutes for rebuttal.
Thank you. A couple things. There's a bunch. Mr. Fontaine does not own the Dinah Towers. Mr. Fontaine does not own Sinvesco. Mr. Fontaine is an owner of a unit. So as the court pointed out, all of the entities are being punished. They're not all owned by Mr. Fontaine. And when counsel said Mr. Fontaine was able to be heard by the court, that's incorrect. At the January 17, 2000 hearing before Judge Nestor, Mr. Rapier said, I represent defendants Dinah Tower, Norma Fontaine, Sinvesco, and Sinvexco. He does not represent and did not represent Mr. Fontaine. Mr. Fontaine was representing himself or attempting to represent himself. The other thing I would point out is when we're talking about court costs and how these costs, if you look between the docket statement, which I'm looking at here, the docket statement, nothing was filed essentially other than one motion by Mr. Fontaine between the entry pointing the receiver and the court's continuation of the receivership. He filed a motion to terminate the receiver because the receiver wasn't producing the quarterly report that he's supposed to. Now, again, I would probably agree with the receiver that he didn't have to, he wasn't out of time. But Mr. Fontaine, that's all he was doing. It was after the plaintiffs filed this motion. And in the hearing in February, the plaintiffs made it very clear what they were asking this court for. They were not asking this court to enforce a settlement. They were not alleging that Mr. Fontaine had breached a settlement. They said, our motion is to amend the order to appoint the receiver.
Yeah, I guess that's my question. Was there an actual motion to enforce the settlement agreement?
Filed by my client, which was, Your Honor, we have a settlement. This has to be terminated. This receivership should be terminated as of February 11th. That's what my clients were asking this court. We have a settlement. Mr. O'Connell can say as many bad things as he wants about Mr. Fontaine and what a pain he is and what he filed. The fact of the matter is they didn't have to settle with Mr. Fontaine or the other defendants. They chose to enter into a settlement. They received their money. They had the receivership remain in effect. They were appointed to the board of the association. They got everything they asked for. And then they said, Your Honor, we've dismissed them, but we want you to amend that order after they've been dismissed. They did not ask this court to enforce a settlement. My clients asked them to enforce the settlement, which was enforce the order which terminates this receivership as of February 11th. That's the only motion. Now what has happened is the court pointed out, all these other defendants have liens on their property. None of them can sell their property. This is an $80,000 judgment. So no one in the association can sell their property. And so that's what that's why you want to understand why my clients are upset about this, is because they did what they were asked to do. Nobody forced anybody to settle.
Mr. Fontaine was never held in contempt, was he?
No, no one asked him to be held in contempt. They just said
I thought they did ask for that.
He filed a motion for contempt. He filed a motion for contempt against the receiver. I'm sure he filed other kind of motion. I thought
the plaintiffs asked for a finding of contempt against him.
Your Honor, I think they may have towards the end. You might be correct, but the court declined jurisdiction over that because the parties had been dismissed and because Judge Nestor was terminating the receivership. So I think at that point, I think there may have been one at that point. But again, nothing with regards to the reason which is we're here is the continuation of the receivership back past February 11, 2019, which didn't get terminated until September. So Your Honor, that's the reason that my clients are objecting to this case, is because every time my clients attempted to, they were told you're dismissed, you don't have standing. But here, we're going to go ahead and amend this order and this agreed entry without allowing you to say anything or to have a say. We're going to amend this order and we're going to continue the receivership. Oh, and by the way, we're going to make you pay for it. When again, you haven't heard anybody say any reason as to why this receivership should continue. The property was in bad shape. Okay.
I thought it was because the receiver didn't get paid.
I don't think that's a valid reason to continue a receivership for another 7 months, because the receiver applied the money that was to pay him instead of to his fees as he was supposed to, and applied them to bills. Because when the receivership was ended and the property was turned back over to my clients, there were still outstanding bills. There were still problems with the property. The property wasn't rehabilitated and become immaculate. There were still issues and problems going on. The receiver just said, yeah, I'm done. Here's what it is. Now, by the way, I have all these bills because I had to fight with everybody, fight with my clients to say, hey, you haven't paid me because my clients are trying to get this property back into their hands. That's what this case is about.
Mr. Custon, you are at your time now.
Thank you, Your Honor.
Thank you both for your arguments. We really appreciate them. A very interesting case. The case will be submitted and we'll get out a timely written decision. Hope you all have a nice day and a happy new year.
You too. Thank you very much, Your Honors.
Take care.